The following paid program is sponsored by the Law Office of Selwyn Whitehead, who is solely responsible for its content. The Law Office of Selwyn D. Whitehead is a designated debt relief agency under the federal law and provides legal assistance to consumers seeking relief under the Bankruptcy Code.
This is Selwyn's Law. Every week at this time, we get to hear from Selwyn Whitehead. She's not just an attorney at law. Selwyn knows her stuff and doesn't shy away from the truth, even when it's ugly. Her Bay Area practice focuses on helping her clients to manage their wealth through estate and tax planning, to managing their debt through reconstruction or bankruptcy. And now it's time for Selwyn's Law.
Welcome to Selwyn's Law with award-winning bankruptcy attorney Selwyn Whitehead. Hi, Selwyn.
Hi, Clifford. How are you doing?
I'm doing really, really well today. How about you? How you doing?
I'm great. Thanks
Excellent.
for asking.
Excellent. It's always good to hear that. Always good to see you. Last week, we were talking about the different kinds of bankruptcy and what it takes to qualify. And perhaps if you can, for folks who weren't with us last week, just kind of quickly, not in great detail, but quickly go over the different kinds of bankruptcy and then pick back up on what the qualifications are.
Sure. I'm going to talk about eligibility, and I thought I'd add in waiting periods because some people have filed before and then say, well, if I filed before, I can't do it again, or when I do it again. So let me quickly go over the eligibility requirements by class, and I'll try to get through this so we won't run out of time. There's four main types of bankruptcies for individuals: Chapter 7, which is liquidation; Chapter 11, which is a reorganization; Chapter 12 is debt adjustment for family, farmers, or fisher persons; and Chapter 13, which is a debt adjustment for individuals. All of them have residency requirements. The business has to be in the United States of America, and where you file your case depends on where either you reside or where the primary asset of your class, your bankruptcy estate, is located. You don't have to be a citizen, but you do have to have a tax ID number. And you have to, if you're an individual, take a credit counseling course within the 180 days immediately preceding or prior to filing the case. Some exceptions apply in emergency situations, but you need to discuss this with competent counsel. So are there minimum debts? There's no minimum debt for Chapter 7, 11, or 13. But for Chapter 12, that's that special kind of bankruptcy for farmers and fisher persons. In the case of farmers, at least 50% of your non-mortgage debt has to be farm-related, and for fisher persons, at least 80% of your non-home mortgage debt has to be from fishing, some kind of fishing-related income generation, or the debts in this instance. The maximum amount of debts in bankruptcy, they adjust every 3 years. There's no maximum amount of debt in Chapter 7 or Chapter 11. There are maximum debts in 12s for fisher persons. It's $1,868,200. For farmers, the maximum debt currently is $4,031,575. And for Chapter 13s, it's split between secured and unsecured debt. You can have no more than $1,149,525 worth of secured debt and no more than $383,175 of unsecured debt. Now, what kind of individuals can file? Chapter 7 can be an individual or corporations, as long as they're not railroads, banks, or insurance companies. For Chapter 11s, it's individuals or corporate entities and railroads. For Chapter 12, individuals or corporate entities, but the primary focus of the corporate entity has to be a family farm or a family fisher person operation. And Chapter 13's only individuals. Okay, income requirements. For Chapter 7, you have to be under a certain threshold of income, because if you have more income than that, it's something called a means test, indicates that you should be able to pay some of your creditors some or all of the debt. There is no income requirement in a Chapter 11 because one might be filing the Chapter 11 to liquidate and pay your creditors off that way. So therefore, you would not have to have income to pay a plan. You just have to be able to sell your asset quick enough before your creditors get angry with you and ask the court to have your case dismissed because it's taken a long time to get what you say you're going to do done. Chapter 12, you have to have regular income. Those are fisher persons or farmers, and 50% of the income has to come from either the production of farming or the production of fishing. Okay, and Chapter 13 debtors have to have regular income of any kind. But it has to be regular and it has to be documented, and it could be gifts from friends and family who want to help you get through a bad situation. If so, they would have to sign declarations attesting that they would continue to provide this to you. Now, the filing fees are different in each of the different chapters of bankruptcy. Currently, and these fees change periodically, currently the filing fee for a Chapter 7 is $335. For a Chapter 11, it's $1,717. For a Chapter 12, it's $275. And for a Chapter 13, it's $310. And this is money on top of what you would pay your attorney because this money goes to the court as part of the filing fee. However, you might be able to either have the fees waived in certain instances because you're very low income, or if you can't get them waived, you can pay them over a period of time, in some instances within 90 days, and other instances 45 days. So if you don't have the money right away, and you might be able to pay it in installments and still be able to file and get your case going to stop whatever the creditor action is that's causing you to look for bankruptcy protection. Now, some people call me and they say, Selwyn, I filed a bankruptcy within the last 8 years. For some reason, there's this myth out there in the ether that if you file a bankruptcy, you can't file another one for 8 years. Well, you can file, but the idea is about whether or not you want to get a discharge. So if you file a Chapter 7 today and you get a discharge in 3 to 4 to 5 months, you cannot file another case and get a discharge unless you wait an 8-year waiting period. So it's filing to filing, not from when you get the discharge. It's 8 years from when you filed the other case. So some people, they keep making the same mistake, or they make new mistakes, and they need the assistance of the bankruptcy court. If you want to do a Chapter 7 and you already have a discharge, you have to wait 8 years before you can file another one and receive the discharge.
Wow.
But you might not need a discharge. You might need, you filed a Chapter 7 3 years ago, and you got on with it, and then the IRS audited you, and they found out, and they audited you for newer years, and now you owe the IRS $100,000. You don't have $100,000. They will not agree to give you, they will not accept an offer in compromise, and while they will take an installment agreement, it's like being on a treadmill. You're paying them money and your bill goes up because the interest and penalties. Well, you might want to file a Chapter 13 with the understanding that you're not going to get a discharge. Now, you can file a Chapter 13 4 years after a 7 and get a discharge, but maybe you need to file it, before that holding period is over. File it. It stops the accrual of interest and penalties.
Okay. That was going to be my question. Why if it's not going to get discharged? But that's why.
So you can pay them the $100,000 over 3 to 5 years, and if you owe them $100,000, that's what you're going to pay. Now, you have to show that you can pay $100,000 because if your plan isn't feasible, it's going to be booted from bankruptcy. But that's what a lot of people, come to me for, or assistance with their taxes, and it's a way to pay the tax man and keep him off your back while you're doing your best efforts. And so that might be a great thing to do. So the holding period, and sometimes you want to file a Chapter 13 for other reasons, such as you got the Chapter 7 discharge, you discharge of all of your debts. Now you want to strip off a lien, a second lien on your house. You would file a Chapter 13 and use the protection of the court and some of the tools that you can use with the bankruptcy code to strip off that second mortgage. So there's I tell my clients, sometimes people call me, well, they're not my clients yet, but they're telling me the bankruptcy law. They're telling me, well, I can't get a discharge and I can't do that. I said, well, who told you that? And I said, I thought you were calling me for me to give you advice. You're going to tell me what you can do. So you just need to, kind of listen to what's going on. So a 13 after a 7 is called a Chapter 20. And sometimes, if you wait the appropriate period, you can get another discharge. And I tell people they shouldn't jump to conclusions, because there's somebody that we know that's in the news quite frequently that files for bankruptcy. I think he's in his 4th or 5th bankruptcy in the last handful of years, and he does it, not him individual, but his corporate entities, because they run into financial difficulties. This last bunch of problems, or it's with a casino in Atlantic City, and people don't have money to go gamble anymore, and a whole raft of casinos have folded. And so Mr. Trump sold a big interest to an individual who put them into bankruptcy to do away with the collective bargaining agreement. So that's something that you can do inside bankruptcy as well. So you have an onerous lease, and you might want to do away with it. You say you're a collection of small retail outlets, and maybe you have 5 different outlets, and maybe you want to get rid of 2 because they're not successful, but you have this long-term onerous lease. That might be a reason to file for a business bankruptcy to deal with that lease. Or you have some intellectual property that you want to deal with inside of a bankruptcy. So there's more than one reason to do it, and sometimes you don't need a discharge. You just need the protection of the bankruptcy court to manipulate some of your relationships with your creditors.
Wow. You just put a whole different spin on everything than I'd ever thought of it before. It's a lot different. So if someone maybe wants to examine looking at the protection of bankruptcy, or perhaps just thinking about actually needing the relief of bankruptcy, how would they get in touch with you?
They can give me a call at area code 510-633-1276, or they can email me. My email address is my name, selwynwhitehead@yahoo.com. And my website is still up. It's going to be changed around a bit, but for right now, you can go on, check me out, see what I'm about. But I've turned off the part that lets you send messages, because we're going to do some reorganization really soon.
Okay, well, real good. Selwyn, thank you so much. As usual, I just learned so much from you, and we'll talk to you again next time with more of Selwyn's Law. Thank you for taking time to listen to Selwyn's Law. Remember, the Law Office of Selwyn Whitehead is a designated debt relief agency under the federal law and provides legal assistance to consumers seeking relief under the Bankruptcy Code. When it comes to your finances and your rights, seek no other than the Law Office of Selwyn Whitehead. Selwyn is your go-to finance attorney, specializing in estate planning, wealth management, bankruptcy, tax, and real estate law. In other words, Selwyn knows her way around the dollar, and your rights are protected by our laws. Protect your money, know your rights. Partner with Selwyn Whitehead. For immediate assistance, or if you have questions, call 510-633-1276. 510-633-1276, and go to selwynwhitehead.com. The preceding paid program is sponsored by the Law Office of Selwyn Whitehead, who is solely responsible for its content.